Quorum is as before.
Yes, correct.
I want to apologize for, just like Mr. Witty, I underestimated my case. I tried using one finger. Like Professor Wajakoya. This is a summary of the ruling. Of course, we know the background of the matter. I will not set out the background. Through learned counsel, Mr. Witty and Mr. Akula, the state opposed release of the first accused on bond of bail, citing grounds set out in the affidavit sworn on 19th May 2025 by the forensic investigator of ESCC, Mr. Robert Roma, which for purposes of this application were clustered into three grounds. First, it was submitted the first accused was likely to interfere with witnesses. Second, it was submitted that the public safety dictates that the first accused is denied bail or bond. Third, it was submitted that the severity of the offenses justify denial of bail or bond. Through his advocates, led by Mr. Mashari and Jeru, the first accused sought to be released on free bond and or reasonable bail and or bond, arguing that the evidence placed before the court is insufficient to make the cut for compelling reasons. Owing to the constraints of time, the submissions of learned prosecution counsel Mr. Mbati, Mr. Witty, and Mr. Akula, representing the state as captured in the court record, are incorporated into this ruling, as if they are set out herein verbatim, seriatim. Similarly, stated by the same reason, the submissions of learned counsel representing the first accused, namely Mr. Mashari and Jeru, Mr. Njiru, Mr. Echesa, Mr. Simiu, Professor Wajakoya, Mr. Ndubi, and Dr. Haminwa, are also captured in the, as captured in the court record, are also incorporated into this ruling as if they are set out in the ruling verbatim seriatim. This court has considered the grounds can be both in support and in opposition of bond and all bail in respect to the first accused. Gathering from the affidavit in opposition to bail, the response thereto, the respective submissions canvassed by all learned counsel, three questions for dissemination have commended themselves as follows. First, whether the state has made a case to justify acquisition of this court to deny the first accused bond and or bail. Second, whether the evidence which was gathered from the first accused's residence situated in the Miliman area within Kitale was unlawfully obtained. And third, whether the constitutional rights of the first accused were violated. I will analyze each question in turn. Relating to the first question, I will summarize. I have discussed the history of bail and bond in Kenya, the Republic of Kenya, both colonial and post-colonial. That led me to the Constitution of Kenya 2010, in particular Article 49, 1H of the Constitution, which is at the center of this application. I also discussed the provisions of sections 123 and 123 capital A of the Criminal Procedure Code. In particular, in actualizing Article 49(1)H, the Statute Law Miscellaneous Amendments Act 2014, number 18 of 2014, dated 24th November 2014, introduced into the Criminal Procedure Code Section 123A, which stipulates as follows: exception to right to bail. Subsection 1, subject to Article 49(1)H of the Constitution, and notwithstanding Section 123, in making a decision on bail and bond, the court shall have regard to all the relevant circumstances, and in particular, A, the nature or seriousness of the offense; B, the character, antecedents, associations, and community ties of the accused person; C, the defendant's record in respect of the fulfillment of obligations and previous grants of bail; and D, the strength of the evidence of his having committed the offense. Subsection 2 provides that a person who is arrested or charged with any offense shall be granted bail unless the court is satisfied that the person, A, has previously been granted bail and has failed to surrender to custody, and that if released on bail, into brackets, whether or not subject to conditions, it is likely that he would fail to surrender to custody. And B, the last condition, should be kept in custody for his own protection. In my mind, therefore, I entertain no doubt that any accused post the 2010 Constitution, notwithstanding the nature of the offense, is entitled to release on bond or bail, save where the DPP adduces facts and evidence constituting compelling reasons. The prominent divergency from the repealed Constitution is that the Constitution of Kenya 2010 now enjoins the court to strike a balance between the rights of the accused and those of the victims. I'm skipping some parts for your own reading. I have cited several decisions in line of that principle of a delicate balance between the competing rights. have also considered the bail and bond policy guidelines of March 2015 and the construction assigned to how that policy has been construed by the superior courts, and in particular in Republic against Richard David Alden, reported in 2016 in the electronic version of the Kenya Law Reports. So I have also discussed diverse considerations in decisional law and diverse grounds in decisional law, most of which I will not read one after another. I will skip to the standard of proof. What then is the standard of proof? And how should compelling reasons be presented? In Java, against the Republic, reported in 1973 reports in page 39, it was held that in opposing applications for bond, that is the Court of Appeals saying, based on grounds set out herein above, it is not enough for the prosecution to make their objections and insinuations. It was underlined that the said objections should demonstrate how release of the accused will be detrimental to justice by being supported by cogent reasons and facts. The decision to grant or refuse bail is only based on probabilities and not certainties. The standard of proof, therefore, is on a balance of probabilities as opposed to the standard applicable in proving criminal charges. Having carefully considered each of the three grounds advanced in support of the objection to bail on bond in the context of the aforementioned discussed statutory considerations, grounds plus the decisional law considerations and grounds, on a balance of probability, in summary, although palpable fear was apparent, unfortunately the evidence presented failed to generate persuasion in my mind that it is more probable than not that the first accused is likely to interfere with witnesses. I further find the grounds of public safety and severity of the offenses unpersuasive. In any event, gathering from the foregoing principles, the apprehension of the state of interference of witnesses and exhibits can be addressed using alternative means in lieu of the drastic step of denial of bond. Wherefore, this court reaches a conclusion that the state has failed to present compelling reasons to deny the fact. Question B, whether the evidence which was gathered from the first accused's residence located in the Miliman area within Kitale was unlawfully obtained. Concerning this question, intentionally so, this court refrains from determining it at this stage on account of the fact that the nature of the question commends itself for determination by the trial court. Question C, whether the constitutional rights of the first accused were violated. Concerning this question, this court too refrains from determining it now on account of the fact that it was raised informally from the bar in a manner stripping it of the manner of pleading such questions as enunciated in the locus classicus narrator. a principle which has received adoration and affirmation by the Supreme Court of Kenya in a litany of cases. Further, this is a question capable of determination in another forum, separate. Disposition. Consequently, in regard to bond and bail, this court directs and orders as follows. A. That pursuant to Article 49, Clause 1, Paragraph H of the Constitution, and Section 123, Capital A, Subsection 1 of the Criminal Procedure Code, the first accused is admitted to both cash bail and bond. B. That the first accused shall be released upon executing a bond of Kenya shillings 1 million with one surety of the same amount. Alternatively, the first accused shall be released upon depositing cash bail in the sum of Kenya shillings 500,000 and providing 2 suitable contact persons whose particulars shall be captured by the registry, including copies of identity cards, their contacts, and other details that may be required to the registry. C. Upon release and while at large, and to address the apprehension raised by the state, the following conditions and restrictions shall apply. Number 1, that the first accused undertakes not to interfere with witnesses and or evidence. Number 2, in order to allow EACC to secure evidence and witnesses, if any, or if there is further evidence to be secured, the first accused is prevented from going to his office at the county headquarters for a period of 60 days running from today. Roman 3, that the first accused undertakes that he shall neither commit any offense nor interfere with the investigations nor threaten witnesses in relation to this matter. Roman 4, that in the event they are protected witnesses, the first accused undertakes not to flout the law and restrictions which govern protected witnesses. Roman 5, that the first accused undertakes to appear before court as and when required. Roman 6, that the first accused undertakes to arrive in the courtroom at least 15 minutes to the appointed time for mention of hearing unless exempted from attending court physically. Roman 7, that in the exceptional occasions where proceedings are conducted virtually, upon directions of the court, which will issue from time to time, the first accused undertakes to join the virtual platform at least 15 minutes before the appointed time. Roman 8, that in case of bond, the proposed surety shall provide security acceptable to the court upon verification thereof. Roman 9, is joined with 8. It provides the kind of surety that is expected by the court. It's a long provision that can be read by yourselves. Roman 10, that all documents provided by the proposed surety as security in this regard shall be subject to verification by the investigation officer at the cost of the state. Roman 11, that the first accused is not permitted to exit Kenya except with the express permission of the court. And Roman 12, that the first accused is warned against offending the sub judice rule. In this connection, except in the court proceedings to ensue, the first accused is warned against discussing in public, including in or with the media, the merits or otherwise of this case. B, that the first accused is hereby notified and accordingly undertakes that breach of any of the foregoing conditions shall attract consequences as prescribed by law, including but not limited to cancellation of the bond or bail terms, with the attendant consequence of being held in remand, prison, until conclusion of the case. Finally, in compliance with Article 52G of the Constitution, the prosecution is directed to supply all documents upon which the state will place reliance to the defense before the next mentioned date. In this regard, the prosecution shall be deemed to have complied by doing the following. A, if any, tabulating the full list of prosecution witnesses, briefly indicating the nature of evidence each witness will present, unless the witness is protected, and the approximate time each witness is likely to take in examination in chief. B, if any, preparing a bundle of documents, binding them serially, with the exception of the bundle retained by the Director of Public Prosecutions for purposes of production in evidence, and tabulating the list of documents in the bundle, describing each document, paginating each serially, and indicating the corresponding number of pages for each document. And where only part of the document is relevant, highlighting the relevant part of the document. C, if the number of documents cannot fit one bundle, the prosecution is at liberty to serialize them in volumes. D, the prosecution is directed to serve the same list of witnesses and bound documents upon the accused or the accused's counsel, whichever is applicable, before the next mentioned date. E, the prosecution is further directed to share with the court the following: the tabulated list of witnesses and the tabulated list of documents only. F, all copies of the tabulated list of witnesses and the state band of documents held by all parties shall be identical to the originals held by the state. Very finally, this matter is allocated to court number 4 for further directions, hearing, and determination. In this connection, there will be a mention before court number 4 on 3rd of June 2025 at 9:00 a.m. for pretrial directions.
Yes, Your Honor, we graciously take your ruling, and we want to appreciate your time. Secondly, Your Honor, we pray for summons for the second accused to report to EACC by tomorrow or the day after tomorrow. That is all, Your Honor.
Thank you.
Sorry, Your Honor, I'll just take the opportunity to thank you for your patience and being able to produce a very detailed ruling within a very short period of time, which we are obliged of. We are grateful.
I also wish to thank you most profusely.
Sorry?
I wish to thank you most profusely for the attention to details that you've given to the matter. I had never any doubt in my mind that you would arrive at the right decision. two issues which I will make reference to very briefly, conscious of the fact that I'm sure you're tired, you've spent more time than all of us combined together. Insofar as the office being secure, the office of the distinguished governor, it is our plea that whatever visits that are to be made by the EACC, or the investigating team, it is only fair that proper notice are furnished and the counsel for the accused person is also present to avoid a situation whereby is prejudiced by whatever activities that may take place in that office. That is one. Secondly, Your Honor, and I say this with a lot of respect, I do not wish to cause drama. I am at a stage in life and in the profession where I prefer to deal with issues as opposed to drama. There's a lot of police officers who are already outside the court, and there's an indication that there could be an attempt again to rearrest the accused person to defeat the very purpose for which this bail has been granted. Consequently, we would wish to receive an undertaking from the prosecution, just as the undertakings have been made obligatory on the part of the accused person regarding how he is to conduct himself. We would also wish an undertaking for it to be given in front of you that there is no intention at all to again cut away the accused person and take him to custody to defeat the purpose for which we applied for bail and which we granted orders after very elaborate submissions. In the event they don't do that undertaking, it is our humble plea, Your Honor, because you can't grant orders that are in vain, that you exercise your discretion and extend that bill to anticipatory bill to also cover any intended arrest, if at all. We are giving an undertaking. In fact, I'm giving a personal undertaking as an officer of this court and somebody who has practiced in these courts and also practiced in independent institutions, that if he is required at any given time, we will surrender. Nobody needs to go to knock at his door. Nobody needs to pounce on him as if he's a criminal for him to be brought to court. We'll bring him ourselves.
Your Honor, thank you very much for what you have done today. Is basically the tenets of justice. In addition to what our lead team leader has said, I would like you to take into account and to give directions to us to the custody of the office of the governor. The custody of the office of the governor should be secure and to be fair on both sides of the coin. Should you make a decision, we would like you to consider that we have a concurrent custody of the office of the governor, so that we do not leave any doubts that may lead to the fruits of a poisonous tree, if I may make that in reference to the Miranda case of 1967, in that any evidence obtained unlawfully without justification will always be rendered unlawful as having been obtained through the fruits of exaggeration. Thank you, Your Honor.
Your Honor, in relation to the 2 months and the office of the governor, You want to bear in mind that the governor's office is executed by the governor and the CECs. Would you be kind enough to give further directions to your honor so that in the event the governor is needed to execute his constitutional mandate, then probably there will be a way of doing it other than that office is his office. And unless it has a branch, your honor, then it means for 2 months the governor is not able to work. And that goes against the constitution, your honor, and against the people of his county. I thank you.
Your Honor, in respect to the same, permit me to address the court on the issue of where we find ourselves as a country in terms of budget cycle. We are in the budget cycle that affects both the national government and the county government.
Sorry, Your Honor. Sorry. We need to understand if Mr. Njero is seeking a review of your decision so that we prepare to answer. Because we understood what was being done on the other side to be comments post the ruling. But the trajectory is taking appears to be intentional on you varying certain aspects of that. We need it to come out clearly so that we prepare, if that's the intention.
Your Honor, we leave it at that. We just restrict yourself to the issue of race, the 2 issues.
From the side, who is leading?
I'll go alone. Yes, I think just 3 minutes. This time I'm sure I have estimated properly. Your Honor, we are agreeable to notice being issued for the ESC when they go to access for propriety, so that the accused person may be represented the council. We are not agreeable, however, to what Professor Jakoya is calling concurrent custody. I've never heard about that. The office has been characterized, at least from our end, as a scene of crime. Your orders capture the protection for both sides, that if the investigators are to access, the notice will be given so that counsel for the accused person is present to protect his rights. We are afraid, or rather I'm afraid, but I've shared with my colleagues, we cannot give an undertaking. You know, the role of the prosecutor is simply to institute an undertake criminal proceedings. While, like I said, I have always had reason to believe Senior Macharia Njero is a man of his word. But I do not have any basis, or I'm not blessed with the same information he has, that there may be an arrest after this. Secondly, arrests are done by investigative agencies. The ODP does not involve arrests. So unfortunately, we can't give that undertaking, but we join him in the hope that there's no arrest that happens. However, Your Honor, very importantly, should an arrest ensue on the basis of the same facts where the court has given a bond, then counsel are very aware that they can come back to you and give and seek appropriate orders. I'm not able to go into possible arrest for any other offense, which I'm not aware of. Maybe Senior would have done better to add additional facts. But for his suspicion, we are unable to give an undertaking. We join him in the hope that there will be no arrest. But if the arrest is to happen, they know how to seek subsequent orders from the court, or even from the High Court, if necessary. We are obliged. Thank you.
Now that you have made it clear, on the first point that there is no objection, that we agree. And the second one, which is extremely important, we are in your hands. We do not want to live by hope. If there was the issue of hope, we're not going to be where we are. So we're in your hands. protect the first accused person, protect the integrity of the order that was granted. I've given an undertaking and you've said that whenever it's required, we will surrender him. And you can join me in that undertaking, both the first accused person and myself. So, with that understanding, protect him. So that he's not again grabbed outside here, immediately we are outside this court.
Sorry, Your Honor, I don't know whether you, with any leave, give me the position to ask. But do we understand senior to also be asking for anticipatory bail of some form? I don't understand. If that is true, then we can respond to that question. Just in that clarification from him. If he's seeking.
As much, I recorded that.
It was an oversight that I didn't respond to that bit. My seniors reminded me. Can I just say one on that? On anticipatory bail? That this court lacks jurisdiction to grant anticipatory bail. And even if this court had jurisdiction, you have no material before you. What you have is the truthfulness of Mr. Macharia, which is not founded on anything else. So, number one, the court lacks jurisdiction, but even if you had the jurisdiction, you have no material to grant bail. Thank you.
Your Honor, just to clarify, you cannot grant orders that I think. And the officers of the court, when they say that Blue sort and hold that the truthfulness, then at the same time you withdraw that truthfulness by saying that it's not material. At the end of the day, you are a judicial officer with powers, you can exercise your discretion and ensure that again your orders are not abused. That's all we ask you.
I have considered the issues. Of course, the first request was from Mr. Mbati, it is granted. The second accused, and of course, serve the summons latest by tomorrow, 10 a.m. refused to attend court not later than 22nd of May 2025. Relating to the question of visiting the office at ESCC, the request is granted. God directs that each time ESCC wishes to visit the office of the first accused, they shall be accompanied by counsel on record for the first accused. Concerning the issue raised by the Honorable Manzo, any order issued restricting a right traditionally is construed strictly in the narrow sense drafted. So, denying the first accused access to his office for a period of 60 days does not at all stop the first accused from working. The denial to access the office means that a physical office, and that is why I specified the headquarters for the period of 60 days. That is what it means. So that office, if ESCC after 60 days they're like, we are done, then if there are issues, the court will be approached. If there are no issues, of course, that will be the end of that restriction. I did not wish to give permanent restriction as yet. However, if other courts in the future think that there is need for permanent restriction, that I'm not in control. What other issue? I think I've clarified that issue.
Potential arrest.
For potential arrest, unfortunately, all counsel seated here understand my limitations. Before I understand, I understand. So I think the High Court is just across the road. You can approach it if there is a problem, but I want to believe we are not acting that way. That's I'm just expressing a feeling. I don't think we want to act that way. The lesser I see about that, the better. Allow me to stop there.
Much obliged.
And the copies, I've seen a few typos. Copies will be available in a matter of about 8 minutes. Copies of the